So I think
I'm just starting the YouTube stream right now.
Okay, just give me the thumbs up when we're ready to go.
And I'll be right back.
Okay,
You should be all set.
okay. Good afternoon and welcome. I am Senator Sharon Carson from District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting that we are holding is in compliance with the right to know law. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order 12 pursuant to executive order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. 6, finally, let's start the meeting by taking roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know law. I will call the roll. Senator Whitley.
Good afternoon. This is Senator Becky Whitley. I'm in my home in Hopkinton. I'm alone in the room, but my family is in the house.
Senator Gannon.
Senator Gannon at home in my office. My wife's in the house, but won't be coming in.
Okay, thank you. Senator French.
Harold French, Senator District 7, broadcasting live from Canterbury, New Hampshire, from my living room. I am alone in the room. I am alone in the house, and everything is secure.
Good to know, Senator. Senator Khan.
Present at home in Keene, and my wife is elsewhere in the house.
Thank you. And Senator Carson, I am at my home in Londonderry, and my daughter is in the room with me. Okay, so we are going to go ahead and get started. I'm going to open the public hearing on House Bill 471. I do not see Representative Roy. Is he a participant?
He is available.
Okay. Before we actually open the bill, for all the attendees, those who would like to speak on the bill, just the bill as it is right now before the amendment, if you could just please raise your hand so we will know that you want to speak on the bill before it's amended. Okay, so we're going to go ahead and I'm going to recognize Representative Roy.
Representative Roy, welcome to the committee. You should be able to unmute yourself.
Thank you very much, and thank you, Madam Chairman, and thank you, honorable senators. I'm Representative Terry Roy from Rockingham District 32. I represent the towns of Candia, Deerfield, Nottingham, and Northwood. I am here introducing HB 471. This is a bill that would make police disciplinary hearings at the state level public. And that is to say that when a policeman in New Hampshire or a policewoman in New Hampshire, they have a certificate that allows them to be a police officer anywhere in the state. The hearings that would revoke that licensure are private right now, and we would like to make them public. That would not include their employer disciplinary hearings, which fall under employment laws, and those would remain as they are. This is strictly for their licensure to be a police officer in the state. I believe that my reason for bringing this forward is because transparency is always, sunlight is the best disinfectant, and we need to have confidence in the people that are enforcing our laws. And it is only right for the public to know that if someone has done something so egregious that it would revoke or possibly revoke their ability to be a police officer anywhere in the state, that the public has a right to know this. And it's very simple at that level, and I'd be happy to take any questions.
Okay, thank you very much for your testimony, Representative. Senator Gannon has a question.
Hi, Representative. How you doing today?
I'm well. How are you?
Good. A little tired, but I'm doing good. Just one question. Just something you just said hit me. You said the public has a right to know when a police officer has done something wrong. Don't you think maybe it's a little premature when they're only at a hearing? Shouldn't you wait till it's been adjudicated and there's a finding of fact that they've done something wrong? Are you not worried that you're going to tarnish an innocent person's reputation prematurely?
Thank you for the question, Senator. No, actually, I don't. Because before they get to that level, there's going to be some type of a department level discipline, which is private. And this is also a name clearing opportunity, not only a tarnishment opportunity. The process itself is what needs to be transparent, so that the public has confidence in what is actually happening and be able to have some insight into the process itself as to how the person defends themselves, what evidence they produce that may be exculpatory. Because if it's private, the results of it are always going to be in question because no one knows how the result was reached. So it's important, just like in many judicial type settings, that the public has a right to see the process itself, to have trust in it, that it's actually functioning.
Follow up, Madam Chair?
Yes, please.
My only one, and I understand what you're trying to do, and I appreciate it. My only one fear is when you're charged, it's on the front page. When your retraction comes in, it's on page 17 in small print. And so I just have a fear for the police officer's reputation being unduly tarnished. But thank you.
If I could just respond to that.
Sure.
Yes.
I agree, and you'd be hard pressed to find a bigger defender of law enforcement in the House. I think that this is helpful for police to be able to say, look, because right now it can be public information that they are having a hearing, but no one knows what happens there. So if it's all done at one time, I feel like this is helpful. If a police officer is accused of something where they're considering revoking his right to be a police officer anywhere in the state versus what happens at his employer, the department, I think it's a totally different level. And I think it's an opportunity, if he is falsely or she falsely accused, to have a name clearing and be able to get that evidence out at the same time as the charge itself.
Last follow-up, Madam Chair?
Yes.
Thank you. Other professions, such as, you may know this quicker than I do off the top of your head, doctor, nurse, attorneys, are there hearings like this public?
I couldn't honestly answer. I think that the Board of Bar Overseers has a certain process, but none of the positions or occupations that you mentioned have the same level of ability to influence and have power over the public at large versus a law enforcement officer. As I'm sure you're aware, the very word of a law enforcement officer is enough to take away your freedom for a limited amount of time and to bring some very serious charges against citizens' names. The mere fact of arresting somebody based on the word of a police officer will make the front page. And I think that the public is entitled to the same opportunities as the police are. So I can't speak specifically on the other occupations, but I would note that they're very different.
Thank you for your answer, sir.
Senator French has a question.
Yeah, thank you, Madam Chair, and thank you, Representative. My question is kind of in line with Senator Gannon's last question, where we have licensing for doctors, nurses, plumbers, electricians, auctioneers, real estate brokers, and probably 100 different other occupations. And if I am correct, and I didn't know if you knew, I believe all those are public, aren't they?
Mhm. Yep.
They are. So the police, a follow-up, so the police are
Yes.
the only ones that are non-public at this time?
Mhm.
Okay,
Yes,
thank
that's
you.
correct.
Thank you.
Okay, are there any further questions for Representative Roy? Okay, seeing none. Thank you very much, Representative.
I'll just hang out here for the next bill.
Okay, thank you. Grant, were there other folks in the room who wanted to speak to the bill itself?
Nobody else has raised their hand to speak on the bill.
Okay.
Excuse me, we just had Gilles Bissonnette has just raised his hand.
Okay, so let's hear from Mr. Bissonnette.
Thank you, Madam Chair. Can you hear me?
Yes, we can.
Thank you, Madam Chair. And if it's okay, I'd like to speak on the police standards and training portion. Will I also have a separate opportunity to speak on the amendment after? Do you want me to segregate my remarks?
Yes, please. You will have another opportunity to speak on the amendment.
Thank you so much, Madam Chair and members of the committee. My name is Gilles Bissonnette. I'm the legal director for the ACLU up in New Hampshire. We support HB 471's underlying provisions concerning police standards and training hearings and how we believe they should be public. Our testimony isn't too different, frankly, from the testimony that we offered on SB 41. I do think to some extent HB 471 is a little bit more streamlined in its language than Senate Bill 441, but we firmly support this. And just to get at what Senator Gannon addressed earlier, we believe that it's critical that these hearings be public so the public can see just how this process works. And right now, for the most part, the public really doesn't have a window into this process. And to reiterate earlier testimony, lawyers and judges as well have their police disciplinary hearings public, even ultimately if there's no finding of wrongdoing. So I just wanted to highlight that just as a lawyer and as someone who's part of the attorney discipline process as well. So with that, I'll conclude my testimony, but I just wanted to echo our support for this bill, just as we supported SB 41 and would hope that HB 471 gets an OTP recommendation. Thank you.
Thank you very much, Mr. Bissonnette. Are there any questions from the committee? Okay, seeing none. Thank you very much. Okay, are there any other folks that would like to speak on the underlying bill?
We just had somebody raise their hand, Ani Malachi.
Okay, why don't we put her through?
Go ahead, ma'am.
Thank you very much. Can you all hear me?
Yes, we can.
Excellent. Thank you. Good afternoon, Chairwoman Carson and members of the Senate Judiciary Committee. My name is Ani Malachi, and my day job is the director of the Human Rights Commission. However, I am not speaking to you as a representative of the Human Rights Commission, but I am speaking to you as a member of the Lee Act Commission. So I was one of the handful of commissioners selected to deliberate these ideas and thoughts and look at law enforcement over the course of last summer to come up with, which we ultimately did, 48 recommendations dealing with accountability, community, and transparency. And as a commission member, I would say that I am also in support of HB 471. I may have some additional comments about the amendment, so I'll certainly save those. But not to belabor the point, but just to say that I am in support of it. And it really works to pull together and actually to really specify and outline a lot of the deliberation that we did over the course of the summer, and the conversations and testimony that was had relative to the exculpatory evidence schedule, and the discussion we had about around what should be done with it and how should it be treated. And to have it in the hands of the Department of Justice makes sense. And of course, they would determine if it moves over to the Public Integrity Unit or if there's another area that would handle it. But to give an opportunity for any police officers that find themselves on this list to have a way to work through that. And then once all of those burdens are met, whether they remain on the list, whether they are removed from the list, then being able to make that public and having further discussions with all of the appropriate stakeholders as to what we do going forward. If there's a way to not have a list, then certainly that makes a lot more sense as we go forward. So I conclude with saying thank you for allowing me to give my testimony. And as a commission member, I am in support of HB 471 and would hope that the committee would vote this to pass. Thank you.
Thank you very much for your testimony. Are there questions from the committee? Okay, seeing none, thank you. Grant, is there anyone else?
One more, Robert Quinn.
Okay, let's put through Commissioner Quinn.
Go ahead, sir. You can unmute yourself.
Madam Chair, if it's okay, I will wait to testify until the Attorney General's office has addressed the amendment, if that's okay for protocol.
That works for me.
Thank you, ma'am.
Thank you. Okay, is there anyone else? Grant?
Those were all the hands we had for the bill as currently stands.
Okay, terrific. So seeing that everyone who wanted to speak on House Bill 471 before the amendment has had an opportunity to speak, I am going to go ahead and open the public hearing on the amendment to House Bill 471, which is amendment number 1118S. Is Senator Bradley in the waiting room, Grant?
I do not see him.
Okay, well.
Oh, no, there he is.
He is. Sorry.
Okay.
He's in under Jeb.
I found him.
Okay, all right. So I will recognize Senator Bradley to introduce the amendment.
Thank you very much, Madam Chair. I like being referred to as Jeb better. You can call me anything you want, just don't call me a Yankee fan.
Okay.
So thank you very much, Madam Chair, members of the committee. First of all, I want to thank the sponsor of House Bill 471 for the willingness to accommodate this amendment, whose purpose is similar to the stated purpose of House Bill 471. I also want to thank all of you who joined in co-sponsoring this amendment and appreciate the bipartisan support. And I think it goes without saying that this is a compromise that was arrived at by a number of different parties, some of whom you have already heard, involving the EES, or the Exculpatory Evidence Schedule, sometimes known as the Lori List. Those parties included representatives of the media, the American Civil Liberties Union, and several entities representing law enforcement. It is a compromise that will allow anyone placed on the EES list to have both due process, an opportunity to clear his or her name, but public disclosure of somebody once that due process concludes. So I'm going to, Madam Chair, stop there. I think you will probably hear better testimony on the details from the Attorney General's office that negotiated this settlement with all of the parties. And I think everybody should be congratulated for coming together and producing this amendment. And again, thanks to all of you that jumped on and co-sponsored it.
Thank you very much, Senator Bradley. Are there any questions from the committee? Okay, seeing none. Thank you again, Senator.
Thank you.
Okay, next we're going to go to Mr. John Formella. Before Mr. Formella likes to speak. I would like the public to know I have to jump off of this hearing. I have a bill that I have to introduce in the House, and just as soon as that process is over, I will be jumping back on. So I am handing the gavel over to the Vice Chair, Senator Gannon, and there you go, Senator Gannon.
Thank you, Madam Chair. Okay, Jenny, tee him up for me.
Mr. Formella, you should be all set and able to unmute yourself.
Thank you, Grant.
Great.
Good afternoon,
Thank you,
Mr.
Mr. Vice
Formella.
Chair and members of the good afternoon. Can everyone hear me?
Yes.
Great. Well, thank you, Mr. Vice Chair and members of the committee. I'm just to kind of, as an intro, I'm appearing before you today as incoming Attorney General and not as Governor's Counsel. My last day as Governor's Counsel is tomorrow, and I will be starting as Attorney General next week. But I wanted to take a minute before I defer to Matt Broadhead of our office just to express my support for this amendment. I want to echo Senator Bradley's thanks to Representative Roy for accommodating the amendment and to the members of the committee for supporting it. I think this amendment represents a very good compromise to address issues that many of us have been discussing for the past few years surrounding the Lori list. Matt's going to go into the details and the background, but I felt that this issue was significant enough that I should come here today just to express that the Department of Justice supports this amendment. If the amendment is enacted, the Department of Justice will work to implement it in a manner that is fair and in a manner that is true to the intent and the understanding of all the stakeholders that came together to develop this language. And with that, I would ask that Matt Broadhead go next to walk you through the details and the background. I will stay on the line, and my suggestion would be that the two of us take questions together after he has walked through the details, if that's workable for the committee.
Sounds very workable. Thank you, almost Attorney General.
Thank you.
Grant, do we
Absolutely.
have-
Mr.
Okay,
Broadhead, you are
Broadhead.
now live in the committee and can unmute yourself.
All right, everyone, can you hear me?
Yes, we can. Thank you. Go ahead.
All right, thank you, John, and thank you, Mr. Vice Chair and members of the committee. And my name is Matthew Broadhead. I'm a Senior Assistant Attorney General, Chief of the Bureau Chief of the Transportation and Construction Bureau, which has in our client profile the Department of Safety. So I'm Chief Legal Counsel to the Division of State Police. Before I get into the substance of the bill, I just wanted to walk you through why we are here and how we got here. It starts really with a prosecutor's duty in a criminal case. Prosecutors in criminal cases are constitutionally obligated to turn over evidence that is potentially exculpatory to a criminal defendant. In a broad sense, exculpatory evidence means evidence that can be used to excuse, justify, or absolve the alleged fault or guilt of a criminal defendant. It's anything, generally speaking, that would be helpful to the criminal defendant's case. So exculpatory evidence does include information that may be used to undermine the credibility of a witness in a case. And a chief witness in any criminal case would be the law enforcement officer who's investigating that case or the arresting officer who witnessed a crime. So credibility is at the heart of exculpatory evidence. A criminal defendant has a constitutional right to this information, and that's established in the U.S. Constitution in a case called Brady v. Maryland. And under the New Hampshire Constitution, that right is enshrined in a case known as State v. Lori, which is the source of the commonly known term Lori list. Since 2017, this list has been known not by the Lori list, but by the Exculpatory Evidence Schedule, the EES list. So the EES list is voluntarily created and maintained by the Department of Justice. Its purpose is to offer a reference tool or aid to state and county prosecutors who have, by nature of their job, have a high caseload. And so it's a reference tool to help them. And it contains a list of law enforcement officers whose employers, state, or local police agencies have determined that their officer's personnel file contains potentially exculpatory evidence. The list serves as a reminder, as I said, to busy prosecutors. So it doesn't excuse their obligation to produce potentially exculpatory evidence. If they review it, they still have to conduct a review of any personnel file, but it is a flagging tool for ease of reference. Since its creation, the Department of Justice has maintained that this record is not a public record and was categorically exempt from the right to know law pursuant to New Hampshire Supreme Court case known as Union Leader v. Fenneman. Last year, the New Hampshire Supreme Court in Union Leader v. Town of Salem overruled Fenneman, therefore calling into question whether or not the EES list was in fact a public record. In a separate Supreme Court case, the New Hampshire Center for Public Interest Journalism and a number of other news media outlets brought a lawsuit against the New Hampshire Department of Justice, and that Supreme Court held that the EES list is not exempt from the right to know under either the personnel file or the internal personnel practice exceptions, but remanded the case to Superior Court to determine whether or not the EES list was subject to another exception under the right to know law. That case is still pending in Superior Court, and we expect that if this legislation were to pass as written, it would resolve that litigation. All of the litigants in that case in Superior Court, except for one, support this bill and were involved in its drafting. Separately, last year, Governor Sununu established a commission on law enforcement accountability, community, and transparency, known as the LEACT Commission. In August of 2020, the commission issued a report containing 48 recommendations to improve policing and transparency in the state. You heard from Ani Malachi, who made that same reference. It was in order to promote the trust among the public, these recommendations. One of the centerpieces of the LEACT Commission's recommendations was to make this EES list public, but to do so in a way that affords law enforcement officers fair notice and due process to contest the designation before the information is made public, something that may not happen in the Superior Court litigation. This proposed bill is, as Senator Bradley and John had alluded to, that it is a collaborative work product. It's incorporating input and ideas from a diverse group of stakeholders, including the ACLU and representatives from various law enforcement groups. And also parties to the litigation. So the amendment before you is solely procedural in nature. We view this as it establishes a procedure under which the names on the current EES list will become public, as well as it's a forward-looking measure that allows for an officer to challenge their discipline that led to being on the list before the name is released publicly. So if I can just briefly walk you through the different sections of the bill, Mr. Vice Chair.
That sounds like a good idea.
Okay, the bill, what it does, paragraph 1 provides that the EES list is voluntarily maintained by the New Hampshire DOJ, and it states that it is a public record, subject to the procedures outlined below in following sections. Paragraph 2 establishes a statutory procedure to make the current EES list public. The DOJ provides notice to all officers on the list, and each officer will have notice and an opportunity to challenge their placement on the list before it becomes public. Paragraph 3 is forward-looking. Paragraph 3 establishes the statutory procedure to make future additions to the list public, and that officers are initially placed on a temporary non-public list while they contest that designation. If they exhaust their grievance remedies, then the name becomes public unless they prevail in overturning the discipline. Paragraph 4 and 5 provide added transparency with respect to the maintenance of the EES list by providing data and statistics that is not currently maintained. And paragraph 6 preserves the voluntary nature of the list and that the procedural and reporting requirements are only applicable as long as the EES list exists. Finally, the language in this bill was the result, like I said, as a mediated compromise that was brokered among our office, or brokered by our office, and among stakeholders. All of the stakeholders have agreed, and I anticipate they're going to testify on it today, and it does underscore the importance of passing this bill as written, given the number of parties involved, the number of cooks in the kitchen, I guess, as it were. So anyway, if you have any questions about the language of the bill, I'm happy to answer them. But that concludes my testimony. Thank you.
Thank you, Mr. Broadhead. I have one first. And it's probably just a simple thing. Why is it that they may voluntarily maintain? Why shouldn't it be? Because you might get someone like me who decides the list isn't necessary. I'm not saying I do, but why is it a may and not a shall? Maintain the list in Roman numeral 1.
Yeah, the department has taken the position that this is just a reference tool, and it will only serve as a useful tool for as long as it's maintained in a certain way. And if we notice that, it becomes unreliable, or if it notice, and it's only so good, the list is only good as the information that we're provided. And another thing that this bill does is it does emphasize due process. And there's been some complaints from law enforcement officers in the past that they were never given any notice that they were going to be landed on the EES list, and they may have very well challenged their discipline in the first instance. So if we notice that there's a lack of compliance and the tool and the list no longer becomes useful for prosecutors, the department would reserve the right to cease that tool. Another component that I would add is that in the LEAC Commission had recommended to stand up a statewide agency that would look into misconduct. The goal is, if that agency is adopted and enacted, the need for the EES list would no longer be necessary. And so it would allow flexibility in that respect.
Thank you. Go ahead, Senator Khan. Did I see your hand up?
Yeah, you did, and thank you. First, I want to say congratulations to Mr. Formella, and look forward to working with you further through this committee and in other ways.
Thank you, Senator.
And for either of you, I mean, Senator Gannon did raise the topic that I'm interested in hearing more from the testimony today. I understand the reservation until replaced by some other administrative body or other review process. That just seemed like so undefined a term that it began to undermine the LEAC Commission's recommendations. So I share the concern that Senator Gannon expressed, and I just would like you to, anything more that you can add to that, I'd be willing to try to understand the reasons for no further definition of the term may.
Yeah, John, I didn't know if you had anything on that, but first, before I address it.
Yeah, thanks, Matt. Senator, I will make a couple points on that. One thing that I think is important to remember is that up until today, the EES has been maintained by the Department of Justice voluntarily. So there hasn't been, the status quo as we sit here today is that there is no statutory requirement for the department to at least maintain the EES. I think for the law enforcement stakeholders that came to the table to negotiate this language, I think there was a desire to maintain that status quo, because if we embark on a new system, I think the thought is that, as Matt said, we want to maintain flexibility in case it doesn't work out the way folks are anticipating. I will say, as incoming Attorney General, it is absolutely my intent to maintain the EES. So this is as much about, this is part of the overall compromise. I think the folks in the law enforcement community who ultimately agreed to this did not want to change the status quo and lock this somehow into statute when it hasn't been that way up to this point. Matt, do you have more to add on that?
No, you touched on it. The voluntary piece. There was a lot of horse trading, I guess, on this, and the voluntary piece was a centerpiece of maintaining the status quo. That's correct. And so that was a thoughtful inclusion, and there might have been other areas where law enforcement, conceded one point or another point in exchange for this voluntary language. As I sit here, I can't recall specifically, but I do know that it's part of the delicate balance that this bill is trying to accomplish.
Okay, thank you both on that. Does anyone else have any questions for either John or Matt? Going? Nope. Thank you both for your testimony today. We appreciate it.
Thank you.
Thank you, Senators.
Grant, who do we have next?
Representative Roy has raised his hand. He would like to speak now on the amendment.
Great. Thank you, Representative. Go ahead.
Thank you. Just briefly, I just wanted to speak as the sponsor of the underlying bill that I am in support of this amendment, and that's all I wanted to say. Thank you.
Okay, thank you. Any questions? Yep, I'm sorry. Okay, Representative, go ahead, Senator Khan.
Yeah, I'm going to continue down the path as the sponsor of the bill and the supporter of the amendment. Does it matter to you if the word shall would replace may?
Thank you, Senator. Somewhat, I think it's worthy of discussion and debate whether it's appropriate, shall or may. I didn't draft the amendment, only the underlying bill. So I do support the concept of the amendment, and I would be happy to work with anyone who needed it to fine tune or wordsmith if it was necessary.
Thank you.
Thank you. Thank you, Representative. Okay, Grant, who's next?
We need anybody now who wishes to speak on the amendment to raise their hand, and we can bring you in. Gilles Bissonnette was first on the buzzer.
Mr. Bissonnette, go ahead, sir. Good to talk to you.
Thank you, Mr. Chairman. Good to talk to you. Can I be heard?
You can.
Great. Thank you. My name is Gilles Bissonnette. I'm the legal director of the ACLU of New Hampshire. On behalf of the ACLU, we are in support of the amendment concerning the EES list. I can also represent that the amendment concerning the EES is also supported by the union leader, which was a co-petitioner in our Chapter 91A lawsuit, as well as the 4 other media clients that I have represented in that litigation concerning the disclosure of the EES, and that's the Keene Sentinel, Nashua Telegraph, Seacoast Newspapers, and the Concord Monitor. As you heard from earlier testimony, the EES amendment was the product of extensive negotiations between litigants and stakeholders, the union leader, the ACLU, the media outlets that I currently represent, as well as the Department of Justice, Governor's Office, and law enforcement. Really, all of this was done in the hope to resolve the public disclosure of the EES once and for all, and also resolve the pending litigation. And I believe as well that this amendment is consistent with the Lee Act Commission's recommendation concerning the EES. And the Lee Act Commission, I know, addressed this issue and discussed this issue extensively. I do believe that this is a strong proposal that not only addresses some of the concerns that we've heard from law enforcement, but also addresses, frankly, the concerns of some transparency advocates like myself, that this list was confidential for so many years. And the ACLU has believed that this list should be public, and this bill will go a long way to accomplishing this. Under this amendment, the public will get access to the names of all officers on the list who should be on the list. The only names that the public will not get access to are the names of officers who timely go to court after receiving another round of notice and succeed in arguing before a judge that placement was improper. All the other names will ultimately be released. And of course, if an officer does go to court and doesn't prevail, that name too ultimately will be released under this bill. I think the last thing I would note is that the police, to some extent already have a right to go to court to seek removal from the list. This bill doesn't add really a new right that doesn't already exist. There are multiple cases right now where law enforcement are going to court seeking removal. Except with this amendment, there's a requirement now that an officer go through this process after a certain period of time if they want to contest placement. And after that point, if they don't, then they had their opportunity. They didn't take advantage of it, and now that name becomes public and really provides, I think, some finality and closure to that particular process. The last thing I would just want to know, because I know that there have been some concerns or a concern raised about the voluntary aspect of the Department of Justice maintenance of the list. I can just tell you that I'm comfortable with the current language, with the voluntary nature of the list, frankly, given that it is consistent with the status quo. So I understand why that language is in the bill. I can also tell you, to the extent that there are concerns from members of the committee, that I can represent to you all that, if the Department of Justice ever, removes the lists or discards the list without an adequate replacement that, addresses defendants' due process rights, I'll be sure to let folks know. That's part of my job, right? So this is something that obviously we actively monitor. I appreciate very much Mr. Fermella's representation that the list is going to be maintained. And I just wanted to flag that for the committee as well. And with that, I'll conclude my testimony. Thank you so much.
Thank you, Attorney Bissonnette. Does anyone have any questions for Attorney Bissonnette? Going. Good to talk to you, Giles. Have a great day. Okay, Grant, who is next?
Next up is Joseph Hubecki.
Okay.
Hold on.
Joe, can you hear us? Yep. Go ahead, sir. Mr. Hubecki, we can hear you.
Hey, Senator Gannon, how are you today, sir?
I am doing quite well, thank you.
I appreciate the opportunity to speak to you and members of the committee. As you know, my name is Joseph Hubecki. I'm the Chief of Police in Hollis. And I also have the honor of serving as first Vice President of the New Hampshire Association of Chiefs of Police. I've been in law enforcement for more than 20 years. And although I'm not originally from New Hampshire, I've lived here for almost as long as I've been a police officer. So I guess that qualifies me as a New Hampshire resident, finally. New Hampshire is my home, and policing is my career and my profession. And I certainly consider myself very fortunate to work in a profession that serves others above self, as I'm sure each of the committee members can relate to. So I'm here today to testify in support of House Bill 471 as amended, into the proposed amendment relative to police disciplinary hearings and authorizing the Department of Justice to maintain the exculpatory evidence schedule. Although the New Hampshire Association of Chiefs of Police supports both parts of the bill, I'll speak only to the EES amendment, as I know my time is limited. Over the past several months, members of the LEAC Legislative Work Group, which I was happy to serve on, worked hard to reach a consensus on this important legislation. In my professional opinion, the language of the amendment is fair, and quite simply, it's the right thing to do. It provides individuals or officers who have been placed on the list, some of whom might not even know that they are on the list, with an opportunity to get off. Moreover, it establishes that an officer added to the list only has his or her name made public after substantive due process rights have been afforded and all appellate rights have been exhausted. So in closing, we feel this is a fair balance that provides a level of transparency that does not exist right now, and one that the public clearly expects. As such, I ask that you and the members of the committee find this bill ought to pass. And I thank you very much for your time and your consideration. And if anyone has any questions, I'd be happy to try and answer them.
Thanks, Chief. I just have a little question and sort of a side thing. You mentioned an officer, it's not really pertinent to the bill, but if you could answer it anyways. If an officer's name appeared, how would he not know that? Wouldn't you have went through an internal procedure and then a hearing? You said someone's name could appear and they might not even be aware of it.
Well, I think there have been some instances in the past where chiefs who are responsible for requesting a person be added to the exculpatory evidence schedule or the Lori list, whatever you want to refer to it as, did not follow process and provide the employee or former employee with proper notification that they would be added to the list.
Okay, thank you. Does anyone else have a question? Yes, go ahead, Senator French.
Thank you, Mr. Chair. Thank you, Chief. I've been an advocate for making this lorry list transparent and open to the public for a long time, and we've had a little pushback because of the problems that you say are now addressed in this amendment. So I'd just like to say to you, thank you very much for working to making this possible.
So it's our pleasure, and I say our because it is a collective effort between various stakeholders, and I certainly appreciate your comments, sir.
Anyone else have any questions for the chief? Chief, I thank you. You have a great day.
You as well. Thank you very much.
Okay, Grant.
Next up is Mark Morrison. Mr. Morrison, welcome to the committee. You should be able to unmute yourself.
Good afternoon, Mr. Chair and fellow committee members. Can you hear me okay?
We can. Go ahead, sir. Thank you.
Perfect. Thank you. My name is Mark Morrison, and I am the current president of the New Hampshire Police Association. I also served on the Governor's Law Enforcement Accountability, Community, and Transparency Commission. The NHPA supports the amendment to HB 471 now before this committee, as it does represent a collaboration of effort that really spans years and represents one of the 48 LEAC recommendations that were unanimously accepted by the commission. And this specific recommendation was one that I brought. This amendment allows for due process rights for law enforcement officers, something that has really, it's been elusive for years. This amendment will allow for basic fairness for anyone on the list. That includes notification they are on it, a way to request a judge to determine if someone should be on it or not, and then the public transparency of publishing the list after it's vetted. This recommendation accepted by LEAC was simple in concept, but required some diligent work by those involved to reach a consensus. Through the months of work by those involved in this amendment's construction, we now have a more balanced approach to deal with this evidentiary issue as it pertains to cases moving through the justice system. I would like to thank those who worked so hard on this amendment and encourage this committee to support this legislation. Thank you for your time today, and I would direct any technical questions about the legislation to the speakers who were intimately involved in its drafting, but I'll take any questions you may have.
Senator Khan, go ahead.
I don't think this will be too technical, Mr. Morrison. Thanks for being present today. It is your sense that with the current wording and the May language in the bill, that the Attorney General's office, the Department of Justice, is expected that you expect them to continue to maintain and make public the Lorry list or the exculpatory evidence list to the public.
I do expect that, Senator. Thank you for the question. But as the speakers who came before me mentioned, whether it's exactly in this form or another, I certainly don't expect, this type of a reporting to go away. It may change hands, it may change forms, and I think that is the appropriate language in the amendment to allow for that. The basic fact of this list is it's been in existence for a long time, and I think before recent memory, there was a lot of discrepancy in how it was either managed or how you got on or what it took. And there has since been, I think, some more formalized process, put in place for this list. And this amendment really sort of culminates all those years of not having a firm understanding of how the list worked, what it would actually do, what it actually is, and then who would have access to it. So this really, I think, culminates all those years of work which is why it is such a big effort to get things done and have this this level of consensus across the board.
Good, thank you.
Thank you. Senator Carson is back. Go ahead, ma'am.
Yes, Senator Gannon, you started the hearing. You can finish it.
Awesome. Okay, Grant, who do we have next?
Next up is John Krupsky. Mr. Krupsky, welcome to the committee. You should be able to unmute yourself.
All right, Mr. Chairman, can you hear me?
Yes, we can. Quite well, sir. Thank you.
Okay, great. Well, good afternoon, Mr. Chairman and members of the Judiciary Committee. Thank you for the opportunity to testify in support of Senate Bill 471 amendment. And the important aspect that I would like to impose upon you is that this is important legislation which creates the delicate balance between the constitutional rights of officers to their good names and reputations and their due process rights, and the constitutional rights of transparency and public information that is important for our democracy. This, the EES list has existed since 1994 under another name, which was the Lorry list. And under the Lorry list, there was a saying amongst police officers that the Lorry list equals liar. And many people were put on the list that didn't get notice, opportunity to be heard, and didn't even know they were on the list till years later. Until 2015, the position was that you could never come off the list regardless of how you were put on the list. And in 2015, the Supreme Court said that you could come off the list if you showed that the reason for being on the list was not substantiated. We have since 2015 worked together with many stakeholders in an attempt to balance the needs of the constitutional requirements of the officers and the constitutional requirements of criminal defendants and the public at large. And we believe that this bill addresses that. It allows the officers due process rights once and for all to go in front of a judge and determine whether or not they belong on the list. And after that is vetted, that it becomes public information for individuals to be able to ascertain if somebody is on the EES list. One of the questions that came up earlier, and I'd like to address very briefly, is the idea of the maintenance of the list. Understand that the disclosure of exculpatory information, whether a list exists or not, is a constitutional requirement that prosecutors have to do. Before there was a Lorry list, that duty was done, and it will be done either way. I believe the list will be maintained. However, there is also other procedures that are used, like, for example, in the federal courts, they have a question and answer whenever you're going to testify to determine whether or not there is Brady or Lorry issues that needed to be disclosed. There are also in the works certain committees, et cetera, who may take over the maintenance of the Lorry list or the Lorry information. And in fact, we have recently agreed in regards to the maintenance of a database for PSTC to maintain when people do certain, or excuse me, police officers do certain acts of misconduct, which would also be exculpatory. So there's probably going to be many databases that are created, and at some point the redundancy is going to be problematic if it's costing a lot of money. The issue here is not to have public access to it, but rather to realize that there may be a better way of keeping this in the future. I had the pleasure of, this is truly a consensus bill. The New Hampshire Police Association, New Hampshire Troopers Association, the Public Defender, the Union Leader, the ACLU, the Chiefs of Police, and the Attorney General's Office all reached consensus on this bill. And we strongly request that you support this bill and that it rule that it ought to pass. And if there are any questions, thank you for your time in regards to this issue.
Quick question just for me, Mr. Krupsky. If you're a police officer in New Hampshire and you go to try to become one in another state, does access to the list follow you? Can other states have access to that list?
Well, I'm only an attorney in New Hampshire, so I don't want to speak to other states' laws. But generally what happens is, regardless of where you go as a police officer, there is a file maintained at Police Standards and Training, regardless of the lorry list. That
Okay.
when you go and they ask you one of the questions, have you been certified by another agency? And you have to answer yes. And then they have access to the records up here in New Hampshire in regards to any of your previous discipline or any misconduct, et cetera, and your status. I would remark that under this bill, if this amendment does pass, that would be a public record and it would be available to anyone once the individuals are vetted. So there would actually be more transparency.
Gotcha. Thank you. Does anyone else have any questions for Mr. Krupsky? Seeing none, thank you very much for your testimony.
Thank you, sir.
Senator, we have two speakers left on this amendment. The first is Mark Bodwin.
Okay, go ahead, Mr. Bodwin.
Good afternoon, Senator Gannon and members of the committee. Thank you for taking the time to hear me on this matter. My name is Mark Bodwin. I am the retired sergeant with the New Hampshire State Police and the current executive director of the New Hampshire Troopers Association. And I'm here today to tell you our support of the amendment to House Bill 471. I'm not going to take up a lot of your time. This is a bill that's long coming. This was an issue that needed to be addressed. I think it balances nicely, as Attorney Krupsky had said, the constitutional rights of the police officer as well as the public's right to know and have transparency. So I'm not going to take up any more of your time other than to say that the troopers support this amendment, and I'm happy to answer any questions that anybody might have.
Does any member of the committee have a question? No, you're looking good. Thank you for your service to the state. Have a great day.
Thank you.
Grant? Oh,
Yes, queuing up our final speaker, or at least the final one that has raised his hand, and that is Ken Norton.
thank you. Go ahead, Mr. Norton.
Good afternoon, committee members. Ken Norton from Tilton, and I'm the executive director of NAMI New Hampshire, the National Alliance on Mental Illness. I was honored to be a LEACT commission member, and I've off and on done training for law enforcement for over 35 years. Also have a bride who was a prosecutor for 30 years, including Belknap County attorney for half that time. So I'm certainly well aware of the challenges and how long the issue relative to the lorry list and now the EES list has gone on. Speaking in support of this, I think we really need to move ahead as a state with this. I really compliment everybody that that worked to strike this compromise. I think it's very consistent with the very lengthy conversations that the LEAC Commission had about this and the recommendations that we made. And I ask you to vote it as ought to pass.
Thank you very much, Mr. Norton. Does anyone have any questions? Seeing none, thank you very much. Have a great day, sir.
Thank you.
We have a couple other hands that have been raised, including Mr. Broadhead from DOJ would like to speak again.
Sure, we'll start with him. Go ahead, Mr. Broadhead.
Hi, everybody. I just wanted to let you know, I think Commissioner Quinn is on, and I believe he wanted to testify on this bill. I just didn't know if he's having some technical issues. I didn't know if Grant had seen his hand raised. That's all.
Okay, thank you.
His hand has raised and then lowered, so it's hard to find him. We have a long list of attendees. Let me see if I can grab him from the general list. And,
Commissioner, can you hear us?
Excuse me. He should be able to unmute himself at this point.
Could you hear me now?
We can.
Oh,
Yes,
great.
thank you very much.
Thank
Go
you.
ahead.
Great. I apologize for the confusion, and I'll be brief. Robert Quinn, I am testifying in support of this amendment as the Commissioner of the Department of Safety. I want to first say, as a member of the LEAC Commission, I worked with Ms. Malachi and our other colleagues very hard over these issues surrounding the EES list. I want to thank the legislative work group, many of whom you've heard from today, who obviously worked very hard to balance the interests. And we've heard the word balance before, but what I would like to say is I truly believe this bill is very important as it balances the interest in the judicial process between a defense attorney and a prosecutor on this important issue. It also balances and gives the officer in a very important issue due process, an ability to explain their case and ensure that that somebody understands, what they want to have brought forward. And lastly, and most importantly, at this time in what we're dealing with across the country, it increases and improves trust with the community, with law enforcement. And I think that those three areas this is done. And again, I strongly support it. And I want to thank everybody who worked very hard to balance all of those issues to come up with this bill today. So thank you very much for the opportunity to testify.
Thank you very much for your work. Anyone have any questions? Thank you, Commissioner. Have a good day.
Senator, we have somebody who's raised their hand identified as Police Standards and Training Council, but does not given a name.
Okay.
Go ahead.
Go ahead, sir.
Madam Chair and ladies and gentlemen of the committee, my name is John Skippa. I'm the Director of New Hampshire Police Standards and Training. I apologize. I was actually listening to Senator Carson open the other testimony on the other side of things, and I was waiting to be called on that side, so I apologize. I speak in favor of amendment to House Bill 471 as a member of the LEAC Commission. I can tell you that specifically the EES list and the EES protocol and process was one of the prime things that we spoke about during police misconduct review and discussion. There was a proposed protocol that was set forth by members of the LEAC Commission. This amendment aligns itself very nicely with the proposed protocol that the commission had worked on. As Commissioner Quinn just said, I'm going to reiterate that the amendment does provide clear, defined due process to the officers. It allows a clear path for redress of any officer who might be on that list. It assists in the ultimate elimination of the EES. And finally, it certainly increases transparency to the public that we serve. And so I want to thank each and every one of you for the opportunity for me to offer my support of this bill. And I stand ready for any questions that anyone might have.
Thank you, Officer Skipper. Does anyone have any questions today? Yes, Senator Khan, go ahead.
Thank you, Mr. Vice Chair, and good to see you or hear from you again, Mr. Skipper. So let me observe. Well, we heard previously in testimony that Police Standards and Training also maintains an exculpatory evidence list. So would you just explain that you maintain one, the Department of Justice will maintain one? Are they the same list? At any rate, you can see where potentially there's some confusion here that we're going to have two lists. So just wanting to understand your perspective on the two departments maintaining a list.
To my knowledge, the only agency that maintains the list is the Attorney General's office, and that list may or may not be shared with the county attorney's office. In the short time that I've been here, I have not seen a list or been privy to the EES list. I don't know, I can't speak to what was done prior to my arrival here. But we, to my knowledge, my personal knowledge, we do not maintain an EES list here. So I apologize if there was any confusion.
Thanks for clearing that up. It was a previous testimony. You probably didn't hear it. But anyway, thank you for clearing that up. And Mr. Vice Chair, just wanted to, not so much for Mr. Skip, but just a note that I was looking, as the chairwoman does, at the sign-in sheet, noticed the 100 people that had previously signed in support, and only one person in opposition. I didn't even see it on the list, but it must be down there somewhere. One of the people who signed in support and said she wanted to speak was Ani Malachi. And I saw her still in the room, or at least on the participant.
Okay. I know she spoke earlier in the day. Did she get an opportunity grant her?
She has not raised her hand. She is available if she would like to speak on the amendment.
Officer Skipper, are you still there?
Oh, I'm sorry. I thought he was done.
No, I just have a quick question for you. So, once this goes public, do you anticipate, is there going to be any rush to the door by police officers? Are we going to lose a lot of law enforcement when this list goes public?
I don't know that this would cause a big rush, because I don't know how many people are on the list. I can't imagine that there are too many people on that list.
Okay.
I certainly can tell you that the immunity question, that may cause some issues, qualified immunity, but I don't see a mad dash for the door on this one.
Okay, thank you. Okay, thanks very much. Have a great day. Thank you for your testimony.
Thank you, sir. Thank you.
Thank you. Do we have?
Ms. Malachi is available. I can bring her in and see if she's there.
Sure. If she wants to speak, that'd be great.
Go ahead. You can unmute yourself if you're there and would like to speak on the amendment.
Thank you all, and thank you, Senator Khan, for remembering. This is Ani Malachi relative to the amendment for the bill that we're discussing now, HB 471. Very briefly, all I would like to say is I support the amendment, and I am certainly congruent with the previous testimony by the variety of law enforcement as well as community members speaking specifically with relative to Ken Norton from NAMI and Attorney Bissonnette from the ACLU. And that is my statement on the amendment. And if there are any questions for me, I'm happy to take them.
Let me see if there are. I'm not sure. Anybody? No, Ms. Malachi. Thank you very much for your testimony. You have a great day.
Great. Thank you all. Bye-bye.
We do not have anybody else who has raised their hand to speak on this amendment.
Okay. Sure. Senator Carson, you want to close the hearing out?
Sure, I'll go ahead and do that. Thank you very much for sitting in for me, Senator Gannon. At this point, we have no other speakers. And so I am going to close the public hearing on amendment number 1118S and close the public hearing on House Bill 471. Okay, next we're going to move on to House Bill 485, which is the next bill we have scheduled. And let me just get the bill here together. I'm going to call on the prime sponsor, Representative Roy.
Representative Roy, welcome back.
Thank you for having me. Again, for the record, Representative Roy, Rockingham 32. I am here introducing this bill today. This bill is really a civics bill. It's as nonpartisan as you can get. This bill is simply requiring police officers, when they ask someone to search their vehicle, to let them know they have the right to refuse that search. It's in a way sad that we have to write this bill. It used to be taught in school what your civil rights were. Unfortunately, as we have seen it's no longer the case, and a lot of people don't understand what their rights are. We already have something similar to this in the Miranda warnings. When someone's in custodial interrogation setting, they are informed of their right to remain silent and to counsel. But on the side of a road in the middle of the night with a police officer shining a light in your face saying, do you mind if I take a look around your car? Many people don't have the understanding that they have the right to say, no, actually, I do mind. All this would require is a police officer to say, do you mind if I take a look around your car? You have a right to refuse, and that's it. I think it's very simple, it's very straightforward, and it's just helping our citizens understand their rights. And I'd be happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Okay. Seeing none, thank you very much.
Thank you.
Next, we're going to move over to Lynn Marie Cusack.
Ms. Cusack, welcome to the committee.
Thank you. Can you all hear me?
Yes, we can.
Thank you very much. I should say that I am here on behalf of the Department of Corrections, and we are in opposition to the bill as written for one particular purpose. When an individual comes onto state Department of Corrections grounds or prison grounds, they are impliedly consenting to a search of their person or their car, especially if the car is unlocked and they are not next to the car. One of the concerns that we have with the bill is that it suggests, as written, that a person, if they refuse to consent, shall not be penalized. In the corrections setting, when an individual comes in, we ask them to be searched. If they say no, they do not want to be searched, then they're asked to leave the premises, and they may then be put on a restriction that they cannot come back into the facility for a certain time. So the way the law would be written, if passed, would hinder the Department of Corrections' ability to disallow that person on the grounds for a limited period of time. The other issue that we saw with the bill as currently drafted was this notion that we would have to wait for somebody or find that individual who belongs to the car, say they're in one of our visiting rooms. We have to go into the visit room, have them brought out, their visit with their loved one interrupted, and ask them first if we can search their unlocked car. A locked car we would not have any concern with, but that unlocked car, we have more than anecdotal evidence that individuals attempt to bring contraband in, and some of our residents in the halfway houses, which are the transitional housing units, or the transitional work center, may be walking through a parking lot, know that car is present and ready to drop something off. So in not being able to go into that car and search, where there's an implied consent already, when you're informed as you're driving in with signs that you are subject to search, we would be forced operationally to change our practices. There are the two big concerns we have with the bill as written. We do understand that it is a civics bill and don't speak to it relative to regular law enforcement and the exception to the warrant requirement that allows consent searches. Under the law in New Hampshire, the law does look at who was present. Did the officers give a defendant requesting consent the authority or the ability to refuse that consent? So we do practice the way the current law is written, allowing them to say, no, I do not wish to be searched. If that's the case, we need the ability to continue to not allow them on the grounds. And someone may say that that would be a penalty, and why we are concerned with the language as written.
Thank you very much for your testimony, Ms. Cusack. Senator Khan has a question.
Thank you, Madam Chair. Thank you for taking a couple of questions. One is, did you provide this testimony to the House when it was considered?
Unfortunately, we were late in getting it to Representative Roy. I learned that it had went on the consent calendar, and at that point, I did we provided testimony to Representative Roy, and it was determined that we should come to the Senate with that testimony. So yes, I was late in presenting it before it made it to the consent calendar.
Okay, thank you. And may I follow, Madam Chair?
Yes, please.
So are you familiar with a notwithstanding like statement in statute? You've probably seen those before.
I have, yes.
Yeah, and would you be willing to prepare an additional section to this? I mean, there's a lot of support for this. So, and we've had a Senate bill that was very similar to this that we've already passed. So, if these bills need an amendment, I think we need to see something from you fairly soon. If you're willing to prepare that, could you say that?
Certainly, Senator Khan. I did provide the requested language to Senator Carson earlier in the week, and I believe that an amendment was drafted up with that language in it, but it has not yet been presented.
I'm good, Madam Chair.
Thank you. And I would just like to reiterate, yes, I did have an amendment drawn up. It is amendment number 1123S. And I'm not sure, Jenny, if I said, yep. So it's already been distributed to the committee. Okay. Are there any further questions for Ms. Cusack? Okay, seeing none, thank you very much.
Thank you.
Next, we're going to go to Chief Goldstein.
Chief, welcome to the Judiciary Committee. You can unmute yourself.
Thank you very much, Madam Chair, members of the committee. Good afternoon. For the record, my name is David Goldstein. I'm currently the police chief in the city of Franklin, and I've been a police officer for 41 years. And I'm here to testify in behalf of the New Hampshire Association of Chiefs of Police relative to HB 485, and we support 485. And hearing just now hearing the Department of Corrections concerns, we would certainly support an amendment relative to that as well. What we just want to remind the committee is that, as Representative Roy put it, perhaps it is a shame that civics is not taught any longer, because this is our practice anyway, to advise individuals that they have the right to refuse a search of their vehicle. And as a result, we don't do that unless we have some other reason to move forward with any kind of case. There are numerous legal decisions over the years that have addressed these issues in both the state and the federal courts as to how to resolve the situations, especially if evidence is either lost or destroyed as a result. And we feel, quite frankly, that it is best left to the discretion of the judge and the courts to ensure due process, et cetera, relative to consent searches. I've worked for 4 police departments in my career, and each and every one has had a formal method of advising individuals that they do have a right to refuse a consent search. And with that, I would be happy to answer any questions the committee might have.
Thank you very much for your testimony this afternoon, Chief. Are there any questions from the committee? Senator Gannon has a question.
Hi, Chief. Good to talk to you today. How you doing?
I'm here, Senator. Thank you.
Just a really easy, quick question. I understand the correction properties are somewhere that they have, they're an exception to the warrant requirement. Are there other places like police stations, government buildings, I don't know, around the State House? Are there places that I also give up that have exceptions to a warrant requirement?
Well, I can't give you a definitive answer. For example, my own police department, no, there's no requirement that you be searched or what have you when you enter or park your vehicle in our parking space. I know, for example, in courts, you have to go through metal detectors, et cetera, for security reasons, which may potentially lead to some sort of search at some point in time. But I don't think there's anything as definitive as the Department of Corrections brings up.
Okay, thank you.
More than welcome.
Are there any further questions from the committee? Okay, seeing none. Thank you very much, Chief.
My pleasure.
Next, we're going to go to Gilles Bissonnette.
Thank you. Thank you, Madam Chair. How are you? Can I be heard?
Yes, we hear you very well.
Great, wonderful. Thank you, Madam Chair. My name is Gilles Bissonnette. I'm the legal director for the ACLU of New Hampshire. I just wanted to articulate our support for HB 485, just as we supported Senate Bill 40, which was a similar bill passed by this committee earlier this year. That bill was limited to vehicles, which is a little bit different from the current bill. Arguably, and this is just for food for thought for the committee as it digests this, arguably Senate Bill 40 might be a little kind of clearer and cleaner vehicle to address this issue. So just one thought for the committee could be to potentially take SB 40's language and replace it in this bill, and of course add any amendment concerning the DOC. This may be beneficial in part because we don't know what will happen in the House with Senate Bill 40. So really, again, I don't know how strongly I feel about that. I just wanted to convey it to the committee as a potential option, given the fact that there's another vehicle on this. And so I don't want to reiterate our testimony from several weeks ago on SB 40. Needless to say, we support this bill and think it's important for people to know what their rights are. Thank you very much.
Thank you very much for your testimony, Mr. Bissonnette. Are there any questions from the committee? Senator Gannon has a question.
Real brief. Thank you, Mr. Bissonnette. Aren't schools a place that have exceptions to warrantless searches? Like parking lots?
Yeah, I don't know. Certainly in the interior of schools, there is a looser requirement, no doubt. That actually, I don't know if Attorney Sher, Professor Sher is on that. He actually has far more expertise on that than I do, and I would defer to him on that. But no, you're right, Senator Gannon. There are places where there are exceptions, and the warrant requirement is loosened, no doubt.
Thank you.
Are there any further questions? Okay, thank you very much for your testimony, Mr. Bissonnette. Next, we're going to go to Albert Sher.
Buzz, you should be all set.
Thanks very much, Grant. Good afternoon, members of the committee, Madam Chair, and all of you. To be very brief, I'm not going to repeat my testimony that I gave on SB 40. I hesitate to get in between Senator French, who was the prime sponsor of SB 40, and Representative Roy, who was the prime sponsor of HB 485. I have great respect for both of them and have had significant conversations with each of them on this bill. I think I would tend to agree with Mr. Bissonnette. I think SB 40 is a little cleaner. And it might be the best way to resolve this. I don't have a huge preference in that direction, but and I would be supportive of the kind of amendment that Ms. Cusack, who suffers from the disability of being a former student of mine, I understand her concerns. As to Senator Gannon's questions about schools. In schools, the police, if the school is looking to search property of a student, they have to have a lesser justification than in general. They don't need probable cause, they need reasonable suspicion. That said, they do need some justification, so that if the police or the school or the resource officer were to ask a student to search their locker, the student still would have the right to refuse, but understand that the authorities or the police would not need as much justification. If they had reasonable suspicion that there was some drugs in there, based on what they might have heard, they're going to be able to do that whether the person consents or not. So yeah, they still have to ask for consent, but they might not bother to do that if they have some reasonable suspicion. Beyond that, more than willing to entertain questions.
Thank you very much for your testimony, Mr. Sher. Are there any questions from the committee? Okay, seeing none, thank you very much. Grant, are there any folks in the waiting room with their hands raised?
Lynn Marie Cusack has raised her hand to speak again.
Okay, why don't we put her through?
She just dropped her hand, so I don't know if she still wants to speak or not. We'll give her a chance to raise her hand again if she wants to. Other than that, we have, yep, she has raised her hand. Here she is.
Okay, there we go. Thank you.
I am sorry, I meant to raise it or lower it, and I did not. I apologize for that. I just wanted to come back on and say thank you for your consideration, and I'm sorry that I had my hand raised.
Not a problem. Thank you very much, Ms. Cusack. Okay, last chance, Grant. Is there anyone else?
We have nobody else. If you would like to speak on House Bill 485, please raise your hand or dial *9. And we do not have any hands raised.
Okay, I am going to go ahead and close the public hearing on House Bill 485. Next, we are going to move on to House Bill 180 and recognize the prime sponsor, Representative Massimilla.
There we go. Representative, welcome back to the committee.
Can you hear me?
Yes, we can.
Okay, thank you very much. Good afternoon, Madam Chair and members of the committee. I'm Representative Linda Massimilla, and I represent the towns of Littleton and Bethlehem. HB 180 was first presented in 2019 as HB 201, went to interim study, and then on to the Criminal Justice Committee, full committee, and proceeded out of committee where it was voted ought to pass. In 2020, on a roll call vote, the House endorsed the committee's report of ought to pass with a 314 to 55 vote. Then COVID happened and the rest was history. This year, as HB 180, it was passed on the consent calendar with a 20-0 ought to pass OTPA. The bill before you, House Bill 180, is similar to the original bill, but it was amended by the Criminal Justice Committee. It still raises the penalty for purchases of sex with a minor to a Class A felony if the buyer is over the age of 20. But as amended, buyers aged 20 and under would be charged with a Class B felony. HB 180 attempts to eliminate the distinctions between traffickers and buyers by recognizing the equal role buyers play in creating a supply and demand marketplace for the purchasing and selling of trafficked children for sex, and therefore creates the same penalty for a buyer as a trafficker. The National Criminal Justice Reference Service in 2017 reported that 41 states had statutes that made penalties for the buyers of commercial sex acts with minors as high or almost as high as the federal penalties, which range from a minimum of 10 years up to life imprisonment. Although New Hampshire cannot quantify the rate of child exploitation, human trafficking has been reported in each of our 10 counties. And the National Human Trafficking Hotline says that there have been 8 trafficking cases and 4 indictments. And in 2018, 29 investigations into human trafficking were conducted, with 79% involving sex trafficking. According to a Boston psychology study by Melissa Farley et al., buyers are most likely to be between the ages of 20 and 75. They're white males with incomes ranging from $20,000 to $140,000. 44% of them have college or graduate degrees, and 40% are married. As we all know, the economic principle of supply is driven by the demand, and the sex trade is founded on this principle. In a Brooklyn School Journal of Law and Policy, it was stated, quote, "The fastest way to dismantle a market is to dissolve the demand." And a similar quote from the Department of Justice study said, quote, "Supply and distribution are symptoms. Demand is the cause." Penalties are not simply put in place as deterrents to crime, but as mechanisms to hold offenders accountable, bringing justice to the survivors and increasing community safety. In a letter on October 28, 2019, sent to the Chair of Criminal Justice by Governor Sununu, it said, quote, "I'm writing to you to express my support of House Bill 201 relative to enhancing penalties for sex buyers exploiting trafficked children. It is my hope that the committee will strongly endorse the measure. It is imperative that we take this immediate action to further protect victims of sex trafficking. We owe it to the children to keep them safe and to hold those who would do them harm accountable," end quote. House Bill 180 does just that. I hope you will vote to pass on this bill. Thank you for listening.
Okay. Thank you very much, Representative. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Okay, next we're going to go to Chief Goldstein.
Chief, welcome back.
Thank you very much. Again, Madam Chair, members of the committee, thank you. For the record, once again, my name is David Goldstein. I am the Chief of Police in the City of Franklin. I've been a police officer for 41 years. For 23 of those 41 years, I was a member of the New Hampshire State Police and had certain assignments that brought me into contact with these types of issues, including undercover work, as well as major crime assignment to the Major Crime Unit. I've also served with the Derry Police Department and as Chief of the Winthrop, Massachusetts Police Department. And at present, I am the Chair of the Chiefs Legislative Committee and have held that position for 11 years. At different times during my career, I've worked cases involving human trafficking, to include the attempted kidnapping and sale of young females, as well as prostitution cases. And I'm here today to testify in opposition to HB 180. The Chiefs are very deeply committed to increasing protections for victims of human trafficking in New Hampshire and ensuring that trafficking in persons is treated as the serious and horrific crime that it really is. We can put as many statistics as we want on things, but there is a human element here that is very important as well. We supported the initial spirit of the bill that sought to raise the crime of trafficking in persons from Class B to Class A felony, and would encourage the committee to reconsider that original language and the intention of this legislation. Crimes of human trafficking are devastating, to say the least, for both the victims and their families. And it's important to hold individuals who partake and engage in human trafficking accountable at all levels. Human trafficking is as severe as other crimes listed under Class A felonies, such as kidnapping, sex crimes, and murder. There is no reason why trafficking in persons should remain at any time a Class B felony. We also want to address the amendment to HB 180 that was introduced and adopted in the House. And this change to the bill created a lesser offense based on age for individuals purchasing sex, something which is wholly inappropriate and goes against federal standards as well when addressing human trafficking cases. This effort to introduce carve-outs for the age between a victim and an offender should not be considered for human trafficking because, and I emphasize this is not an issue of being in a relationship. This isn't boyfriend, girlfriend. It is the unintentional purchase and objectification of a human being. It's deeply concerning that we might apply the same approach to statutory rape as human trafficking, and we strongly urge the committee not to pass this bill with these changes. Thank you very much again for this opportunity, and I'm happy to answer any questions the committee might have.
Thank you very much for your testimony, Chief. Are there any questions? Senator French has a question.
Thank you, Madam Chair. Thank you, Chief, for appearing today.
My pleasure, sir.
In your experience, has there been a lot of what's addressed in Section B? Have you seen that? Where actors under the age of 20 are actually propositioning younger women?
I don't know if I can answer that objectively, Senator. I can say I've certainly seen it.
Yeah.
I've been involved with it, but to put an actual number on it would be very difficult for me. Perhaps there are better studies that we could access. I would only say that when I began my doctoral program, the first book I had to read for statistics and methods was How to Lie with Statistics. So
right.
I think that we have to keep that in mind as well.
Okay. Thank you, Chief, very much. I appreciate the time.
My pleasure.
Are there any further questions for Chief Goldsmith? Senator Khan?
Thank you, Madam Chair. Thanks, Chief, for your testimony. Did the Chief Association support the bill in 2020?
I believe we did at the time for the, it wasn't lessening the penalty, if I remember correctly. I'd have to go back, quite frankly, and look at our notes. But I believe we did.
But it is your testimony today that you support the original version of this bill.
Yes, sir.
Thank you.
Specifics, I'd have to go back.
Okay. Are there any further questions for Chief Goldstein? Okay, seeing none. Thank you very much, Chief.
Sure.
Next, we're going to go to Bob Dunn.
Mr. Dunn, welcome back to the committee. You should be able to unmute yourself.
Thank you, Grant. Thanks, everyone, Senator Carson, members of the committee. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester. And on behalf of Bishop Peter Labaschi, I want to express our support for HB 180. Human trafficking is something that is of major concern to the Catholic Church here in New Hampshire and around the world, because the sort of the universal nature of the church puts it in the front lines of where human trafficking is happening and really terribly attacking the liberty and the human dignity of the people who are impacted. And in fact, Pope Francis has called human trafficking a crime against humanity. And one of the things that I think is important to recognize is, you know, because I think I know myself, in years past, confess that I did not have a firm understanding of the immediacy of the problem here in New Hampshire. But the New Hampshire Human Trafficking Collaborative Task Force, which is comprised of state and local and federal law enforcement agencies and other stakeholders, was created precisely in order to address the urgent need of a coordinated response to the human trafficking threat. And the fact that that task force exists at all is clearly a strong indicator of how seriously New Hampshire law enforcement officials view this problem. The issue of the amendment is an interesting one. I think obviously all of us, and I don't want to speak for Representative Massimilla here, but I think everyone who was a supporter of 180 in the House was happy with the bill as it existed without that carve out. I think that the reason that the carve out exists was really more of a political issue. It was one of those things where there were folks that were on the Criminal Justice Committee that wanted to see that in there. And so I don't think it's ideal that it be there, but the question is whether or not that language is necessary in order for this bill to be able to pass both bodies. So it's one of those difficult questions about whether it's necessary to accept something less than the best possible language in order to make sure that the good parts of the bill actually pass. So that's something that I guess I would be happy with the original version of the bill, but I guess it just everybody needs to do some sort of an assessment about whether or not the bill is going to be able to be passed without that amended language. And with that, I thank Representative Massimilla for bringing the bill forward and for her leadership on this issue. And I thank you for your consideration.
Thank you very much for your testimony, Mr. Dunn. Are there any questions from the committee? Okay, seeing none. Thank you.
Thank you.
Next, we're going to go to Joy Smith.
There we go. Ms. Smith, welcome to the committee. You should be able to unmute yourself.
Thank you so much. Good afternoon, Madam Chair and members of the committee. My name is Joy Smith, and I am the Program Director at the New Hampshire Coalition Against Domestic and Sexual Violence. We are the umbrella organization for 12 community-based crisis centers who provide free and confidential services to nearly 15,000 survivors of domestic violence, sexual assault, child abuse, and human trafficking each year. I am also a core member of the New Hampshire Human Trafficking Collaborative Task Force, which was established by New Hampshire Senate Bill 194 in 2007. We are a group of law enforcement officers, service providers, attorneys, state agencies, and community stakeholders who respond directly to human trafficking cases in the Granite State. I'm here to speak in opposition to the recent changes made by HB 180, which seeks to increase the penalties for buyers under the law regarding trafficking in persons. I want to thank all of you for the opportunity to share my testimony today. Human trafficking is a serious matter here in the Granite State. The statistics show that there was an increase in the number of victims seen in 2020. Out of the total number of confirmed victims, 53% were victims of sex trafficking and 43% were labor trafficking victims. Of those victims, nearly 40% were minors. So tragically, one of the most common forms of trafficking that we witness in New Hampshire is familial trafficking, where youth are at risk of exploitation within their own family units. It's imperative that our state laws take a clear stance against human trafficking. In order to do this, we must work towards holding both suppliers and purchasers accountable through addressing the supply and demand sides in the trade of human beings. Creating an exception does not allow us to acknowledge trafficking in persons and children as the severe and horrific crime that it is. It is with this in mind that the coalition supported HB 180 as originally introduced at the start of the legislative session, which sought to increase the penalty for purchasing a trafficked person from a Class B felony to a Class A felony. We feel that this is an appropriate change to our human trafficking statute and acknowledge the severity of these terrible crimes. Moreover, this would bring New Hampshire closer to the federal law where it comes to prosecuting crimes of human trafficking, and it would be consistent with other state human trafficking laws, which treats this crime as a Class A felony or a minimum 15-year sentence. We strongly urge the committee to support increasing this penalty from a Class B to a Class A felony. However, we have significant concerns regarding the amendment to HB 180, which was adopted by the House and would create a lesser felony for persons under the age of 20 who partake in and purchase human trafficking. There is no place for this type of carve out from a human trafficking perspective, and it sends the message that the age of the buyer somehow makes the crime and level of exploitation less severe. Individuals who are within certain age groups should not be given leniency for the intentional exploitation and purchase of human beings. This amendment is not in alignment with federal policy and goes against best practice in our statewide efforts to end human trafficking and to hold perpetrators accountable. To introduce the so-called Romeo and Juliet clause that is typically applied in statutory rape cases completely undermines the level of abuse and trauma witnessed in human trafficking cases, especially among minors. Sex trafficking is the exploitation of a person through force, fraud, or coercion. It is in no way comparable to a relationship. New Hampshire would be taking a giant leap backward in our efforts to address human trafficking should this provision be adopted. It would leave many child victims more vulnerable, and it fails to acknowledge the type of exploitation that occurs in these cases. We are also unaware of any states that have these types of statutory carve-outs. There's absolutely no need for New Hampshire to be creating a loophole for a person partaking in human trafficking to further manipulate and abuse child sex trafficking victims and to lessen the culpability of purchasers in the state. We urge the committee to consider removing Section 3B of HB 180 and passing the bill as originally introduced so that any purchaser, regardless of age relative to the victim, is guilty of a Class A felony when engaging in human trafficking here in the Granite State. Thank you for allowing me the time and your consideration, and I'd be happy to answer any questions that you have.
Thank you very much, Ms. Smith. Are there any questions from the committee? Ms. Smith, I have a number of questions, and I hope you can indulge me because I'm also looking at the amendment that was placed on the bill, and I find it very troubling that you're talking about creating a lesser offense for someone who buys or pays for sexual activity with a person who's 13 years of age or older and under the age of 16, and the actor is 20 years of age or under. It's my understanding that someone is legally an adult at age 18, so I question why we would have that 2-year difference in there. And secondly, are we now saying that a 13-year-old can legally consent to engage in sexual activity for pay with someone, and the buyer, if they're 20 years or older, younger, they're only going to get hit with a Class B felony?
That is essentially what our concern is with this amendment.
Okay. Yeah, I've read it, and we've gotten a lot of email over this, and I just personally looking at this, I just don't understand why this exception was put in there, because when you talk about trafficking, you're not talking about a relationship. You're talking about the buying and selling of a human being. And that is not any kind of a romantic relationship under any circumstance. So again, thank you very much for your testimony this afternoon. Are there any further questions for Ms. Smith? Okay, seeing none, thank you.
Thank you, Madam Chair.
Okay, next we're going to call Darlene Pollock.
Go ahead, ma'am. You should be able to unmute yourself.
Thank you so much for hearing me. I am holding a baby, so if he starts complaining, I apologize in advance. For the record, my name is Darlene Pollock, and I am a juvenile sex trafficking survivor from here in New Hampshire. I was sold first on my 14th birthday after being groomed through my 13th year after years of sexual abuse, which is very common in sex trafficking. I ran away from home and ran away from abuse at home, which is also very common. And I would ask you to support House Bill 180. As originally written would be great. The carve out I did agree to because young people are stupid. And the way that the amendment ended up getting written, I found it very confusing. I don't like the way it's written. I think it's too vague and open to interpretation. But as has been stated, trafficking itself is very demeaning. I was an implement to be used and not a person for 4 years in and out of the foster care system and on the streets. And I've been thrown out of cars and beaten up. And, you know, a lot of people think that they're buying sexual encounters, and they're not. Oftentimes I was bought specifically to be abused, to be roughed up or raped. It was a very common experience for me. And I do agree that it should be a felony. And I thank you for hearing my testimony, and I'm open to questions.
Thank you very much for your testimony, Ms. Pollock, and it's a pleasure to see you in front of the committee again, testifying on this very important issue. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Darlene. I don't have a question. I just, again, want to thank you for your bravery and coming to share your story and your testimony with us. We really do appreciate that.
Thank you. Thank you very much for hearing me.
Are there any further questions? Okay, seeing none, thank you.
Thank you.
Grant, are there folks in the waiting room that would like to speak?
We have one person with their hand raised. If you'd like to speak to House Bill 180, please raise your hand or dial *9. The one person who has raised her hand is Catherine Cooper.
Okay, thank you. Good afternoon, Ms. Cooper.
Thank you, Senator Carson and members of the committee. I'm here testifying today on behalf of the New Hampshire Association of Criminal Defense Lawyers, and I am testifying in order to point out a very serious flaw with the way that this statute is drafted. I testified to this problem when the original bill was put into effect. I also testified to this problem in February in front of the House. And the problem is with the way the statute is drafted. Section 3A actually does not include an element that the person who is the victim has been trafficked. I'm sure that this was just a mistake in drafting the bill, but essentially the actual elements of the statute as written are basically the same as RSA 645-2. It sets out basically the same crime, which is asking or paying for sex with someone under the age of 18. I recognize that that's not the intention, that the intention is to include that the person has been trafficked, but it's actually not included as an element of the offense, which is a serious flaw. So when a statute is evaluated or analyzed and the court in a jury trial, for example, is setting out the elements of the offense that the jury has to find evidence of beyond a reasonable doubt, this, just because it's housed under a title that includes trafficking does not mean that trafficking is actually an element of the offense. And you can see in the statute as drafted, the paragraph before, the paragraph after, trafficking is actually part of the offense. But the paragraph that we're dealing with here, 3-A, does not require that element. So I would ask that the committee take this opportunity to fix that. It's clearly the intent that the person has to be trafficked in order to have this higher penalty, but as it's drafted now, it does not require the person to be that the person has to be trafficked in order to be found guilty of this crime. So,
thank you very much for your testimony, Ms. Cooper. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you, Attorney Cooper, for taking my question. Is this an issue that had been raised in the House?
I did raise it in the House, and in fact, I raised it before this committee when the original statute was passed. So it's been a problem for a couple of years, and it hasn't been fixed yet. So I'm trying again.
Thank you.
Thank you. Are there any further questions? Okay, seeing none. Thank you very much, Ms. Cooper.
Thank you.
Grant, is there anyone else?
No one else has raised their hand to speak on House Bill 180.
Okay, I'm going to go ahead and close the public hearing on House Bill 180.
Senator, I'm sorry, Linda Mazzamilla, Representative Mazzamilla is putting her hand up.
Yep, just after I said that.
All right, very quickly, okay.
There you go, Representative. You should be all set.
Thank you, Madam Chairman. I do agree that I agree with Chief Goldstein and Joyce Smith and Darlene Pollock that the bill as it was originally introduced was my intention. The amendment was put on by the Criminal Justice Committee. I also agree with Catherine Cooper that the word trafficking needs to be included in Part 3A. So if the committee would like to amend this in any way, I would be more than amenable to that.
Okay. Thank you very much, Representative. Any questions from the committee? Okay. Seeing none. Okay, I am going to go ahead and close the public hearing on House Bill 180. There were 28 people who signed in support and 2 people who opposed. Okay, I'm going to open up the public hearing on House Bill 286 and recognize the prime sponsor, Representative Klein Knight.
Hello, members of the committee. Can you hear me?
Yes, we sure can.
Thank you so much, Madam Chair and members of the Senate Judiciary Committee for hearing this bill, House Bill 286, which came out of a couple months ago. There was a homeless encampment surrounding state grounds in Manchester for a couple of days, and it was in the news. I know some of us may be more familiar than others, but long story short, we didn't really have a plan to house these displaced people, which had also been exacerbated by COVID. So we saw more homeless people than we've ever seen before in Manchester, some from surrounding towns, some from even out of state. And in between my state responsibilities, it was a couple blocks away from my house. I did do shifts there to bear witness and to offer people support and resources where I could and point them in directions of substance use, rehabilitation services, and other shelters in the area. Now, law enforcement, state law enforcement did get there, as we know, and did have a plan, not for the people, but to protect the property. And when I was there, I witnessed state police come to facilitate the resurrection of a large fence that would go around the property. We were informed that everyone had to move their belongings as fast as they could, because it was a race for the people that were erecting the fence. They said, if the fence reaches your belongings, we're throwing them away. I spoke to people that were getting their medications thrown out, their social security cards thrown out, their worldly possessions that they had had since being displaced. There was no clear plan on reuniting these people with any of these belongings or assessing them for life-saving medications that they were on. There were so many state cops around that had nothing to do because there was no aggression, there was no danger to public safety. There was one man that refused to leave his tent and he was arrested. But besides that, I witnessed around 40 state police officers standing there laughing. They did not know I was a state representative. Volunteers were scrambling everywhere to push people's belongings to safety. People were crying, people were in crisis. Some didn't have boxes. We tried to get as many people's stuff and themselves to safety as possible. I'm 5'2". I tried to push somebody's shopping cart full of stuff. As the fence was getting closer, they said, "You better hurry up." They laughed at me. I fell over and hurt myself as I was trying to push this cart full of stuff away, and they just stood there laughing. I have never, and I'm not a homeless person, and I felt my dignity and the lack of treatment and care that I was seen as a human. It just really hit home for me, and I feel like because of the homeless situation in our state and because people are struggling so much more than ever before, we can't just not have a system to reunite people with their medications and their social security cards. And we really owe it to the people in our state to really take a good look and to have some sort of protocol in place as to what happens when we need to protect a state property, but how we also can respect the dignity and humanity of those that have fallen on hard circumstances. And I want to reiterate a problem that I see happening as well, since we don't have a plan that we've come up with, we are wasting our own taxpayers' money to continuously house homeless people via the incarceration process. So I don't think it's fair to our people to spend money like that. And I don't think it's fair to any one of us that could be homeless and fall on hard times and may be treated the same way that these people were treated. So this did pass on a full bipartisan support on a vote. It was on the consent calendar and the House passed it on Wednesday via voice vote. This is a good faith bill to do right by our people that have been suffering the most during this pandemic, and to show them that we care and we are working together across the aisle to come up with a solution so we don't treat people like this anymore. Thank you.
Thank you very much for your testimony, Ms. Klein-Knight. Excuse me, Representative Klein-Knight. Are there any questions from the committee? Okay, Representative Klein-Knight, do you know if advanced warning was given to these folks that were staying on the property?
They were told that they had to leave and that it was going to happen soon. There was the times that I believe were coordinated with the head of who, I'm not sure if it was the governor that was in charge, but it seemed to me, because I was there every day, that the times kept changing and they were looking for a way to clear it out when the least amount of people were there so that they wouldn't have witnesses. And what I saw and how I was treated by the police personally really disturbed me.
Okay, all right, thank you very much, Representative Klein-Knight. Are there any questions from the rest of the committee? Seeing none, thank you very much, Representative.
Thank you so much for your time.
Next, we're going to go to Janet Lucas.
Senator, I do not see anybody with that name in the group. If he or somebody else would like to speak on this bill, please raise your hand or dial *9. And I have no hands raised.
Okay, all right. I am going to go ahead and close the public hearing on House Bill 286 and just say that there were 53 people in support of the bill and there was no opposition. Seeing it is 3:07, the committee is going to take a 15-minute break. And then when we come back, we will talk about executing some bills. See you soon. Jenny,
Yes, Senator.
could you please, I've already printed off a copy of the original House Bill 180 for the committee, for myself, but can you get a copy of that and make sure every committee member gets a copy of the original? Because I know just taking it off, looking it up, we get the amended version.
Sorry, Senator, I don't think I quite understand what you're asking.
Okay, maybe it's been a long 3 days. Could you please send as introduced copy of House Bill 180 to all the members? We might even be able to deal with this one today. I'm not sure. It's going to depend. I see Rick is back with us. If we even want to deal with this one today, and we can maybe just do a committee amendment. It's just a question about where to insert the word trafficking. So that's a possibility.
I heard that just as I was signing off to go over to federal court.
Okay. Yeah, there's a lot of, I think, well, when we get in, we're going to be getting into executive session, and we'll discuss it in executive session with everyone. We're waiting for Senator Khan.
Something interesting I found, the web page has the statute all screwed up.
Really?
Yeah. The numbering on it is not right.
Wow, okay.
Because I was trying to see if this fell into that mandatory 7 year. There's a part of it that's got a mandatory minimum 7 years.
Yeah, I remember we did that, or we talked about that a few years ago when we worked on that, and we were getting away from the minimum mandatory. And I know that we had talked about doing away with that, but I know that I wanted to have a 10-year minimum, especially for trafficking children, but it didn't go anywhere. So
it does not have a typo. It only looked like a typo because of the way it was formatting on my screen. Looked very strange. All right.
I think we're just waiting now for Senator Khan. I'm not sure if Senator Khan is going to be coming back, because he did send an email saying that he had another, he was attending a video conference. So I'm going to go ahead and take the committee out of recess, and I will entertain a motion to go into executive session. Moved by Senator Gannon. Is there a second? Seconded by Senator French. Okay, I will call the roll. Senator Gannon.
Yes.
Senator Whitley.
Yes.
Senator French. He's disappeared.
Yes. He said yes.
Okay, and I don't believe Senator Khan is with us. As I said earlier, Senator Khan had a previous engagement, so we will be missing him today. Okay, oh, and Senator Carson, yes. So we've heard a lot of bills in the past couple of weeks. There are some that I believe that are just not ready, that might need a little more time for us to take a look at. One is, well, I'll just name them: House Bill 197, House Bill 331 FN, which deals with the forfeiture of personal property, House Bill 108, which is a bill that we heard on Tuesday, House Bill 178, which is the parole of prisoners and procedures of the Adult Parole Board, House Bill 239, which is relative to prosecutions for certain assaults against minors, House Bill 270, relative to post-conviction DNA testing, House Bill 615 FN, reducing the penalty for certain first offense drug possession charges, and House Bill 427, which is prohibiting corporal punishment of children in state agency programs. So I will be looking to exec these on Tuesday of next week, along with either the bills that we heard yesterday along with the bills that we heard today. Hopefully that's going to give folks enough time to review if there are amendments, and we can hopefully begin to move on some of these bills on Tuesday. So what I do have is a number. I think there's 1, 2, 3, 4, 5 potential bills that we can do today. Even though one of them is one we just heard, I think it's relatively straightforward, and that is House Bill 286. And I apologize, I kept referring to Representative Klein Knight as Ms. Klein Knight, but it is Representative Klein Knight. This bill is establishing a committee to study the response of law enforcement and the criminal justice system to homelessness in New Hampshire. Do you folks feel that, oh, hello, Senator Khan. Do you folks feel that this one is ready to come forward?
Yeah.
Sure.
Okay, Senator Whitley?
Yeah, I would say, so I would say that there were 53 people in support, no opposition. I would say that this is, you know, came over from the House. This would be an easy bill for me to support.
Okay, great. All right, so can I get a motion on House Bill 286?
I move ought to pass.
Okay, we have a motion of ought to pass. Is there a second?
Second.
Seconded by Senator French. Is there any further discussion on House Bill 286? Okay,
Well,
Senator Gannon?
I certainly felt her pain. I understood wasn't handled well. And certainly the government should be more involved in the homeless situation. I think it's just getting, and they didn't treat her well. But all that being said, I don't see it as the police's responsibility for our problems in homelessness that's getting blamed on them. I do feel bad that they mistreated her. They laughed at her. That was all wrong. But I think our problem of homelessness isn't the law enforcement's fault.
Senator Whitley?
I would say that regardless of how you feel about the role of law enforcement, like they actually do play a role. So, I mean, that's just a fact that they do play a role. And so I don't see any, you know, and the bill actually isn't even specific to this incident. It's more sort of general about the role of law enforcement in homelessness. So, you know, that's an issue we see in Concord too. You know, it's one that just needs to be looked at and see what is the role, right?
Okay, Senator French?
Yes, thank you. Yeah, I feel this is a good time for this bill. This will give the police the authority and guidelines on what they should be doing to help move along these people. If you're in Concord ever and you look at the homeless encampments that are abandoned, all you see is like a bomb went off with all this trash all over private and public property. And I think it would be good to have a study for this.
Okay. Are there any further comments?
Well, I agree. It's a terrible problem that we need to address. I disagree with it being fostered on the hands of law enforcement. I felt other officials should have done something about this. And it was just it's their fault that they pushed them away. Well, we did nothing.
Well, Senator Gannon, I'm going to have to disagree with you. Sure. Because it's a case of when a city has a problem with homelessness and they have to move people, or they go to folks and say, look, you can't be here. Oftentimes people they stay there, and this is where the police become involved. And so it doesn't hurt anything, it doesn't harm anything to take a look at how the police handle this situation. It would be interesting to see how police from around the country handle this issue as well, because I think homelessness is not just an issue in New Hampshire. We know it's an issue in our country, and it's been exacerbated by the COVID-19 crisis. Look at some of the executive orders that were done both statewide and federally to protect people from getting evicted from their homes and from their apartments or their living places. Just because those executive orders went away doesn't mean the problem went away either. So I think it would be a good thing to, I think, take a look at this and have a discussion with law enforcement about their role and what can we do to treat the homeless with dignity and respect, and how can we find a way to involve law enforcement in a positive way. And I'm not saying that law enforcement is not positive, but I think sometimes they're put in difficult situations where we're asking them to do a lot of other things outside of their job of catching the bad guys. So I'm going to be supporting this bill, and I'd like to thank Representative Klein-Knight for bringing this forward. Are there any further comments or questions? Okay, seeing none, I'm going to call the roll. Senator Gannon?
No.
Okay, Senator Whitley?
Yes.
Senator French?
Yes.
Senator Khan?
Yes.
And Senator Carson? Yes. So we have a 4-1. It will not go on the consent calendar. Senator Whitley, would you like to take this one out?
Happy to.
Okay. Okay, next we have.
Can I change my vote? I don't want to make a big deal out of it.
You don't have to make a big deal.
No, I don't. We don't need the half hour on the floor. We got plenty to do. I
Good
just
Okay.
I want to
move,
rethink.
Senator.
Okay,
I
no.
disagree with you, but I who knows? I'm
Okay.
wrong once a year.
So I
Move
need,
for reconsideration.
Documented it. We have it documented, Senator Gannon.
I said once a
Okay.
year.
Senator French has moved reconsideration. Is there a second? Seconded by Senator Khan. I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson. Yes. Okay, is there a motion to come forward?
Motion for consent.
No.
Motion about to pass.
Oh, I'm sorry. I'm
Yep.
way ahead.
Senator French moves ought to pass, seconded by Senator Whitley. Is there any further discussion on the ought to pass motion? Okay, seeing none. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson. Yes. Senator Gannon makes the motion for consent calendar. Is there a second? Seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson. Yes. Senator Whitley, will you still be responsible for the little blurb?
Yeah.
Okay. All right. Let's look at House Bill 296, and you should have received an amendment this morning. It was amendment number 1141S, and House Bill 296 FN establishes the crime of unsolicited disclosure of an intimate image. What this amendment does, it just clarifies the third section that says that you have to have been convicted that they're only going to be guilty of a violation for a first offense and a misdemeanor for the second or subsequent offense occurring after the conviction of the first event. So you cannot have these multiple events going on. They've got to be convicted of the first offense, and then they will be charged with any subsequent offenses. Do I have that correctly? Okay. Are there any questions on that amendment? Okay, is there a motion on the amendment number 1141S?
Move ought to pass.
Okay, Senator French moves ought to pass. Is there a second? seconded by Senator Gannon. Is there any discussion on the amendment? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Okay, can I get a motion on House Bill 296 as
Move on.
amended?
Move on to pass as amended.
Okay. Senator French moves ought to pass as amended. Is there a second?
Second.
Seconded by Senator Whitley. Okay, is there any discussion on the ought to pass as amended? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
So moved.
Moved
Oh,
by
that was
Senator
fast.
Whitley. Hey.
I'll second.
And seconded by Senator French. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. And Senator French, would you like to take this one out?
I would, Jen.
Okay. All right. Next, we have House Bill 530, which is relative to candidate background checks for law enforcement officers. Is there a motion on House Bill 530?
Motion for ought to pass.
Okay, we have an ought to pass motion. Is there a second?
Trying to find it here.
Yeah.
I don't know why I
Senator-
practice with you, Harold. It just doesn't work.
Oh,
This is,
I'll
five-
second it.
There you go.
okay, all right, here we go. So we have an ought to pass motion. Is there any discussion on the ought to pass motion? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan, Senator Khan,
Yeah, sorry. This is,
House Bill 530.
I'm looking at it. I'm sorry, I wasn't ready for this one. I'm going to vote against. I probably should have offered some discussion on this. I'm sorry.
Okay, all right, and Senator Carson, yes. Okay, so this one will not go on consent calendar, and I will take this one out. Okay, next we have House Bill 375, which is allowing the destruction of valueless contraband by chiefs of police.
Move on to
it-
pass.
Okay, Senator French moves ought to pass. Do you second? Okay, seconded by Senator Whitley. Is there any discussion on House Bill 375? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
okay, Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. So this is,
Move consent.
passes. Okay, Senator French moves consent. Is there a
Whitley.
second? Senator Whitley moves to, seconds the bill. Is there any discussion on the consent calendar? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Okay, Senator Gannon, would you like to take this one?
Sure. Yes, ma'am.
Okay. And I think the last one is House Bill 180. I don't think we should take this one up. I thought maybe we could. It might take a little work to do this. I've asked Jenny to send all of you a copy of the original bill as it was filed. I don't think we're ready for this one. So
Yeah.
Please, I'm sorry, Senator Whitley.
I would say that, based on the overwhelming testimony, it does look like we should, go back and look at the original language
Right.
of the bill, and that's where I would be heading.
Okay, yeah, I agree. Senator Khan?
Are we going to take up the addition of the word trafficking in 3A?
Yes, I think that we need to look at the amendment that the House placed on the bill, which I think there's some problems. It seems the testimony that we heard was based on that amendment. And then Ms. Cooper's recommendation that we add the word trafficking in. So I think we're going to have to work on that one. And so I don't think that one's ready. So I think that's what we have that we can do today. And so I will, just before we're through, want to thank all of you for this week. Jenny?
Sorry, Senator, I just want to quickly note they are holding the calendar for us until tomorrow. So anyone that is taking a consent blurb out, I'll send it to you as quickly as possible. And if you could just get it back to me as quickly as possible, that would be great.
Okay, thank you, Jen.
Can we meet tomorrow?
No. I was trying to say thank you to everybody. This was a tough week. We met for 3 days. We heard 16 bills, which is quite a bit, and some of them were very serious. All of them are serious issues. I just want to thank all of you. We did get 23 more bills yesterday, and I've scheduled out till the end of this month, and we will be hearing 3 bills next week, the 3 fiscal note bills, and then we're going to exec the following bill. The following week is the same, 3 bills, 3 FN bills, and exec. What I'd like to shoot for is by the end of April that we will have finished all the fiscal note bills and whatever bills that we are currently holding. And in the month of May, we'll finish the additional 17 bills that we received. And I think that that's definitely manageable. We might need to take a couple of days here and there. I hope you all should have gotten a master sheet. So please take a look. You can see again, some of these bills that we're going to be receiving they're big issues. So I want to make sure that we all have time to read and digest and ask questions so we can vote what's in the best interest of our constituents. So I will entertain a motion to adjourn for the day.
So moved.
Senator Whitley moves to adjourn. Is there a second?
Yeah.
Come on, Jay, do it.
All right, Senator Khan. Seconds the
big
motion.
effort.
There you go. All right. Is there any discussion on the adjournment?
Well done this week, Madam Chair.
Well, I couldn't have done it without all of you. We truly are a team and we work together.
I just don't understand Jay wanting to work all weekend too, but
Well, I think that's a personal discussion you should have with Senator.
I will,
Khan.
Jay, I'll be calling you.
Thank you. Could Jenny send us the list of bills that you want to exec on Tuesday?
I will have to give her that list because I just have all the bills in a pile in front of me, but I will definitely try to get something to her for tomorrow. I think Fridays are work days for us just as well. And we all have Zoom meetings that we do on Friday. So I will try to get them a list to her tomorrow. Okay. Okay. We had a motion to adjourn. It was seconded. I will call the roll. Senator Gannon.
Yes.
Senator Whitley.
Yes.
Senator French.
Yes.
Senator Khan.
Yes.
And Senator Carson. Yes. Again, thank you all so much for this week. We couldn't have gone through it without all of you. And we will see you next Tuesday. Everybody.